In a majority ruling delivered by Justices Helen Obura, Moses Kazibwe Kawumi, Eva Luswata, and Dr. Asa Mugenyi, the court held that petitioners seeking divorce must still provide evidence of matrimonial offences to justify the dissolution of a marriage. The petition, filed by lawyers Nicholas Opio, Isaac Sali Mugerwa, Dr. Kabumba Businje, and Stella Nakajiri, sought to have the law reformed to allow courts to dissolve a marriage upon proof of a retrievable breakdown, especially after mediation or reconciliation efforts have failed.
Ground one, where we were challenging the fault-based divorce system, has been declined by court on reasons that those provisions can be brought into adaptation to the Constitution, and they do not in any way contravene the sections that we had the articles that we had put forward.
The justices, however, held sections 4, 5, 6, 7, and 8 of the Divorce Act, stating that the proposed consent withdrawal model is not grounded in constitutional law. The court rejected the argument that requiring proof of recognized divorce grounds violates rights to privacy, dignity, or a fair and speedy hearing. It noted that parties may request to proceed in camera in private or use initials to protect their identities. A major development in the ruling came on sections 15, 16, and 18 of the Divorce Act, which deal with property acquired by a wife after judicial separation. The court found these provisions discriminatory because they only protected wives and excluded husbands. The majority ruled that these sections must be interpreted and applied equally to both spouses, ensuring gender equality in property rights after separation.
Historically, women never actually used to have the right to own property in their marriage. In fact, to a great extent, they themselves were actually considered property.
Justice Frederick Egonda Ntende dissented, arguing that once one spouse withdraws consent to remain in the marriage, the law should not require burdensome proof of adultery, cruelty, or desertion to dissolve the union. The ruling means that parties must continue to rely on recognized legal grounds to obtain a divorce under the current act. However, activists and legal reformers argue that the continuous reliance on the adversarial trial-like process re-traumatizes spouses and forces the disclosure of deeply personal details.
Now, if you prove this ground not to the satisfaction of the judge or the judicial officer, they will keep you married. But in actual sense, you're not what? You're not married.
Lawyers representing Dr. Kabumba and Nicholas Opio expressed disappointment after the court rejected their bid to modernize the colonial-era Divorce Act into a more progressive consent withdrawal model that would eliminate the need to prove matrimonial offenses.
And sometimes people would refuse to give you a divorce depending on which party is angry, and then it will drag the case.
Other stakeholders had this to say.
To me, I believe in the rule of law, and once you take me to court, you need to bring evidence and prove that the allegations that you bring against me are true.